Yeah, absolutely. I mean, that kind of holds true for any party, whether it's a condo association or an HOA or a business or an individual. Um, you never know what's going to happen when you get in front of either a judge or a jury. The attorney can give you advice as to what your probability of winning is. Your attorney can give you the pros of your case, of your position, and the cons, the weak sides to your case. But nobody can make any guarantees. And further, with a condo and an HOA association, is the idea is to have a community that's within harmony in itself. You don't want contentious relationships between the boards and the members. Now, obviously, we know that doesn't happen, and if that didn't happen, then I wouldn't be doing that kind of work. There'd be no need for attorneys other than drafting of documents. So there are problems that come up, and sometimes, there are cases that are close calls, and there's a reason for them to be litigated because the association thinks they have a really good position, and their attorney is telling them they have a really good position. And sometimes at the same time, same case, the member counsel says, no, you have a good shot at this. And so those cases get litigated. But a lot of times there are attorney's fees. Most of the time, in fact, there are attorney's fees that are involved. And the prevailing party is entitled to attorney's fees from the losing party, so you risk that. Court costs, which are going up higher and higher. The losing party is usually responsible for that, and the time and effort and psychological effect. Even on, the association is actually a corporation, they're an entity, but the board of directors are human beings, and they have to spend time with cases that are in litigation. So if you can avoid litigation, it's always best to do that. And you can do that through negotiations. And then the statutes also provide alternative dispute resolution to litigation. So they have pre-suit mediations that are required for HOAs in certain circumstances, and for condominiums, it's non-binding arbitration before you can actually file suit. But it's best if you can negotiate it without having to even go that far. But if you can work it out in mediation and arbitration, that's certainly preferable than going to court. But if if an association has to go to court, or a member of an association, then that's certainly something that is always a possibility with any dispute. So you try and minimize those the best you can.